The purpose of this video is to simulate that first meeting with your family lawyer. The point of that first meeting is to do something that is pivotal. It's to empower you. Our clients that come in through our doors for the very first time are often afraid, depleted, and they're in the dark. Where am I going with this? What does it entail? How long is it going to be? How much is it going to cost me? How is my husband or wife going to react to my decision to trigger proceedings against them? How are my kids going to react? So imagine how much emotion the client is going through when they walk through that door for the first time and sit in front of a lawyer when none of those questions are answered. In a short period of time, our objective is to try to give you as much information as possible to appease your sense of where am I going and to give you a sense of direction. That then allows you to make an informed decision as to whether or not the timing is right, the cost is right, the lawyer is right, and you're right in the moment for this decision. A divorce file has so many tentacles. You're dealing with the fact that one of you is about to pull the trigger on the proceedings. You still have a house to live in, a mortgage to pay, children to feed, children to see, schools to pay for, bills to pay. Life keeps on turning. Finances keep on turning. Well, it just can't stop. So the first thing to know is, when one of you has decided to institute family law proceedings, urgent measures need to be put in place to at least ensure the status quo. So what's the status quo? And how can there even be a status quo if everything is changed? Well, the point, especially if there are children involved, is to minimize the change as much as possible at the outset. You're going to have decisions that are made on who's going to have the kids and on what basis. Where are the kids going to live? Where are you going to live? How are the immediate and urgent expenses, those recurring expenses, how are those going to continue being paid and by whom? So the status quo really means that if both parents were pretty much involved in the parenting of the children, you can expect some form of shared custody. But if it was one parent who was really the principal parent, the status quo should have it that that parent who was the principal parent would retain most custody of the children on an interim basis, on an urgent basis, on an immediate basis. You can expect that both parties will continue to share in the expenses once the separation is triggered. But how is that status quo even established in court? The first thing you need to know is to stop the hemorrhage, a judgment needs to be put in place, or the parties need to agree immediately on these urgent matters. And how do you do that? Well, if you're going to go to court and let a judge decide because you haven't been able to come to a decision together, mutually, amicably, then you have to explain your position to a judge. And on that, I want you to think about going into the emergency room and going through triage. When your arm is broken, you rush yourself to the emergency room, you see the emergency doctor, you see the emergency nurse, you wait a little bit, and then immediate measures are taken to stop the hemorrhage. The long-term solution, the physio, the rehab, that comes later. You get to court soon after you've decided to institute proceedings or soon after proceedings have been instituted against you. And you see a judge in an urgent setting. And at that time, you don't have much time to explain yourself because there's 50 other cases behind you that are also waiting for an urgent judgment. So how do you convey your position to the judge? You do it through an affidavit. And what's an affidavit? It's a written statement of your position. And that affidavit is then subject to a response from your spouse who has to file his or her own affidavit. And that affidavit will also say, well, this is how I see things. And therefore, these two affidavits will deal with the urgent measures. This judgment is usually in place for a short period of time, anywhere between 30 to 90 days. And then you want to get yourself out of that interim pattern and get yourself to a second level. The first level is the interim level. The second level is the provisional level. So what's the provisional measures? It's essentially part two of the interim measures. It's all those urgent situations that have been the subject of an agreement or a judgment, and then instead of having affidavits being able to be the main piece of testimony that the judge will weigh on, the judge now has the benefit to hear the testimony of the people that can now support the allegations that were initially in your affidavits. So now you get to testify. And now a judge has the time to weigh on your body language, on your tone, on your credibility, and can listen to other testimony that can corroborate what it is that you want. And so, you now have a much broader spectrum and far more time to be able to expose your claims to custody, to the finances, to the use of the home, and other urgent matters. That provisional judgment will be in place until the final trial. The trial. It's the bridge that allows for everything to remain in place until you have your last chance in front of a judge, which is the reiteration of everything you did on the provisional hearing, plus the less urgent matters like how do you divvy up the RSPs, the RESPs. Some people fight over aeroplan points. But what's maddening is what you're hearing me say essentially is that you are relitigating the same urgent issues 3 times. And that's why these custody and divorce cases can be quite lengthy and costly. And it's our job to weigh the risks of going through that entire spectrum and seeing if there's anything we can do to alleviate the burden on you and your family and get to a deal and an agreement as quickly as possible without sacrificing what is vital to you and to the children. You have to know where you are today and where this could potentially be headed. And that also allows you to assess a few other things. 1, is this the right time to be doing what you're trying to do? If you're not sure about instituting proceedings, you now know the mechanism that you have to go through in order to get from starting point to end point. 2, you need to know if you have the financial resources to go through the entire process. We don't know how long it's going to take because we don't know what's happening on the other side, how intent they're going to be on fighting, how intent they're going to be in contesting everything that you're asking for, or how intent you're going to be in contesting what they're asking for. It can be a lengthy process, and you have to know if you're financially ready for it, if you're emotionally ready for it. Number 3, who else are you involved with? You're involved with a lawyer that you're going to choose. That interview, essentially on that first meeting, is a 2-way interview. The lawyer needs to feel genuinely connected to you pretty much from the get-go, and you need to be connected to that lawyer almost instinctively. Why? Because it's a very emotional process, which means that every time you pick up that phone, you want to feel comfortable with the person that you're speaking to. You want to like the tone of their voice. You want to like how honest they are. You want to like that you're being billed in a way that you're comfortable with. But that person is in your finances, in how you're raising your kids. You're building a partnership with an attorney who's seeing you through one of the most challenging times in your lives. And that lawyer also has to assess, am I the right person for the job? You can have the legal skill set to do what you need to do. But if you don't feel that there's an emotional fit with the client that allows you to help that client, then it's best for that lawyer to walk away. Both of you need to make that assessment. The point of that first meeting with a lawyer is to empower you with information. You came in with a bunch of questions, and now you're leaving with another form of anxiety because you've got a bunch of answers that you've got to deal with. But you're supposed to feel empowered, and you're supposed to feel a sense of direction. But take your time. While you're making this decision to separate, you're also grieving the loss of the family that you once knew. So you can't act quickly or impulsively unless there's something that's extremely urgent that's happening and that requires immediate action. So that was our first meeting. Thanks so much for watching. Please leave me any comments you'd like to, and I'll be happy to answer you. And I'll see you on the next video.